Hello, everyone. Welcome back to our association leadership series. We have got a great topic today about leasing in your community. And I want to welcome back Donna Berger DiMaggio of the Becker Law Firm. Donna, welcome back.
Oh, good afternoon, James. Happy to be here.
You know, Donna and I kind of caucus once a quarter and say, what is our audience going to want to talk about? And you know, obviously the SB 4D law was a big one in Florida, and budgets, hurricanes, and we have done webinars and all that. And so in our last meeting, Donna goes, what about leasing? I thought, I'm not sure whether that's a, you know, a really exciting topic, but you wouldn't believe how many people we had registered for today. So Donna, I stand corrected. For those just joining us for the first time, welcome. And just wanted to give you a recap of kind of how we're going to go. We received literally hundreds of questions in advance, and I've kind of synthesized those in this presentation. And so you are welcome to send in your questions as Mariness instructed at the beginning, and they're coming up to me live in the screen. I won't get to answer them all, but I will factor them into our discussion. We also often get asked for past webinars, and we have them all at castgroup.com. Just hit on the webinar tab and you can watch as far back as you wish. But honestly, some of them are very, very good, even though you hadn't thought you had interest in that at the time, that they're highly relevant now. The other thing I want to say, a couple of things just administratively. Donna, of course, is very generous with sharing her brilliance, but she is not giving us legal advice today, although some of it will certainly sound that way. And the other thing is, I know we have mostly Florida, but some Texas watchers today. And Donna is, of course, only licensed here in Florida, so take that. But honestly, a lot of the principles of renting in a community are going to apply to everybody. If you have any questions along the way, just email them to info@casagroup.com. And the other thing I want to say is there's actually more laws. We're going to talk about this affecting condos and co-ops and HOAs. So we'll try and make that distinction as we go along. But Donna, before we jump in there, you know, when we had our meeting this week about this topic, you had brought up, ironically, 3 12/31 deadlines that are lining up for our condo boards. The first one being this year, 12/31, and that's the first reporting requirement that came out of Senate Bill 4D. Do you want to give us a quick a highlight of that?
Sure. So the deadline is, as you stated, James, it's the end of this year, 12/31/22, and you have to go in. If you're a building that's 3 stories or higher, you have to go in and submit information to the state, basically saying how many stories you are and what your location is. I've actually filled out the form just to see it. It takes less than a minute to do, but you do have to submit that information. We have it on a site we created called flbuildingsafety.com. You can also go to the division's website and fill that form out. But if you are 3 stories or higher, now there are some people that think every association, every multifamily building has to fill it out, even if they're 2 stories or 1 story. I believe it's 3 stories or higher, but if you want to go ahead and fill it out, no matter what you are, go ahead and fill it out.
Well, that's that's good advice. I think that the other one was 12/31/23, and that was the bill again, mostly for, well, I guess for mostly condos. It could be an HOA or a clubhouse or something with an elevator, but it is the rules about elevators.
Yep, anyone with an elevator by the end of 23 has to have safety doors installed. That was a change to the Florida Building Code. I have a lot of clients right now undertaking those modernization projects. So speak to your elevator company. If you've got an elevator, you've got an elevator company. So speak to your elevator guy or woman and ask about the upcoming deadline. You probably already know about it, but you do need to know that that deadline is coming up quick.
Excellent. And Ness, let's take down the agenda now and keep the questions up, Elsie. So, and then the third one, 12/31/24, is the ELSS law deadline. So just give us a quick update on that. We'll jump into we'll jump into the leasing topic.
Sure. So the ELSS is Engineered Life Safety System. That's for all of our listeners who have pre-1992 high rises, which are defined as 7 stories or higher. If you haven't already installed a full sprinkler system, retrofit it with a sprinkler system, or installed what's called an ELSS, which consists of partial sprinklers, self-locking doors, pressurized corridors, your deadline is coming up, and that is the end of 24. I will tell you, James, that there has been the belief, this has been a deadline that's been looming for 20 years, 2 decades. And a lot of people still think they're going to get additional time. I don't think that's a realistic expectation. I think you're at the end of the road here. So hopefully if you're listening and you haven't made plans to install your ELSS and you are pre-92 high rise, after you get off this webinar, you're going to make a few phone calls.
You and I have been talking about that one literally for decades. By the way, Donna, there's 3 questions on the board. And I just want our audience to know I've read them because they're all included in my questions to you today. One is on screening, which we're going to talk about. And can you do it more than just on a lease application? You don't need to answer that now. We're going to get into that. And then the other question is about using a standard lease, a required lease, which we're going to talk about. And the third is the implications of the HUD rule changes. So my audience, I will address all of those, or I should say Donna will. Okay, so I thought we should start though. Ness, let's put up poll question 1. I forgot to mention this in my introduction. I'm getting rusty here, Donna, but I really wanted to know in our audience how many of your communities are allowing rentals, and it'll lead me into what really drove this, Donna. I think when you and I got talking was 2 things that really stood out to me as a property manager. One is the short-term rental issue. Airbnb and VRBO have literally changed our world in terms of the use of real estate. And as much as we may not like those in our community, and a lot of us restrict them, if you're an investor, this is a dramatically higher return on your investment. So I get it. Keep both the questions and the polling up, please. And so, and the second thing though, and this is really interesting, we now have, it's become an institutional asset class for big investment houses to buy single family homes. And they're buying them in HOAs. And I mean, there's the possibility, we haven't had the situation yet, where you could have institutionally owned 51% of your community, and all of a sudden they're electing your board of directors. So it was the short term and the institutional investor aspect that I think really drove us to have this conversation.
Well, we also have investors purchasing in HOAs, James, single family homes and creating sober homes. I've got that in a few of my communities. And if we have time, we can talk about how to deal with that issue as well.
Okay. Let's look at the poll results, Ness. How many of our audience are, wow. Yeah. So
I told you, James.
I know. I knew I'd have to say, Lori.
98%.
Yeah. Are we sharing those results, Ness? Good. All right. All right. So let's talk about where I'm a board of directors, Donna. My documents say nothing. Let's start there and then kind of work down the authority that we have as a board to restrict or not rentals. So our documents say nothing. Are our owners allowed to rent in our community, condo or HOA?
Correct. Condo or HOA, your documents are silent on this issue. That implies legally that it's permitted, that the activity is permitted. So the first thing to understand is if your documents say absolutely nothing about leasing, whether it's permitted or prohibited or screening or anything, it means legally it's going to be seen as permissible, okay? And if you want to get a handle, let's say that over time, as you said, you've got more people buying for investment, you've got people leasing out, and you've got some troublesome tenants. Now it's time for your board to sit and start thinking about how do we want to create some guardrails here around leasing. And that's when you pick up the phone, your manager, you speak to council and you say, we want to amend the documents. Because if you just want to pass a board rule, that's going to create a conflict because your superior document, the declaration in a condo or an HOA, or the set of bylaws in a cooperative, that's going to create those are the superior documents. And if they are silent, you cannot create rules that creates a conflict with those superior documents. So you will need an amendment to your governing documents approved by your members.
I think there's a couple of points I want to draw out of that. First is, above the governing documents would be statute. Are there statutes that our board should be concerned about before they even talk about amending their documents? Or what kind of laws are statute driven that affect rentals in our communities?
So nothing in 720, but in nothing in 719. In 718, there is a grandfathering of rental rights. It's in 718.110 subsection 13. And this was passed, oh God, I think it was back in 2004. And Senate President Jim King was in place at that point. He had a very good friend who had just bought in a condo, James. He was a guy from Maine, very good friend of the Florida Senate President. He bought in this condo, and 6 months later, his neighbors voted to restrict leasing. And this gentleman wanted to continue leasing. So he went to his good friend and said, there ought to be a law. And that was the genesis for 718.110.13, which is the grandfathering of rental rights, which says now that if you want to pass an amendment like what I just suggested a minute ago, that restricts leasing or restricts the number of times you can release, or imposes a minimum or a maximum lease term, that amendment is only going to apply to existing owners who vote yes, or new owners who take title after the amendment is recorded. That leasing amendment is not in a condo going to apply to current owners who don't vote at all, or current owners who vote no. But I tell clients that's not a reason not to go forward with a leasing restriction, because over time, units change hands, and over a span of a number of years, everybody will be bound by that restriction.
You mentioned section 718, 19, and 20. Again, 718 condo, 719 co-op, 720 HOA. And that particular law affects 718, which is the condos. And we often get asked about grandfathering, but it's statute-driven grandfathering in that case. In terms of, I'm thinking of state statutes, though. Chapter 83 is Landlord-Tenant Act is in that chapter. Is that relevant to associations? Obviously, it is between the owner and their tenant, but is that a relevant chapter to our discussion today?
It will be, when we get into the uniform lease and the uniform lease addendum, we're going to talk a little bit about Chapter 83 and the rights and obligations of landlords and tenants. Chapter 83 is 100% going to apply when an association takes title to a unit, James, and then releases it out. So in that effect, the association becomes the landlord and will be bound by the provisions of Chapter 83 of the Florida statutes. But in terms of a unit owner renting out and the tenant, they are both bound by Chapter 83. The association is bound by the provisions of 83 as it pertains to their handling of a security deposit. And we're going to talk about that too. Associations are entitled to take a common area security deposit, and 83 is going to dictate when you have to return that security deposit. In other words, if your tenant comes, I've got a security deposit for any damage that tenant leaves, I can't just keep that security deposit. You have to return it.
Okay. By the way, we had a question come in and it came out of, I think, the grandfathering discussion. So theoretically, you're going to have potentially in a condo, one neighbor that can rent and one that can't because of the change, but that's just the way it is, correct?
Yeah, it is, and it's important. So this is a housekeeping issue. This is why it's really important and to keep very good records as to who voted. You're going to want to keep those voting materials indefinitely, because that's what you're going to use when you're applying the rental restriction. Because remember, it applies to those owners who voted yes. I've had people who forgot they voted yes. So that's number one. But you're right, and I will tell you, the Florida legislature has spoken numerous times about extending that to HOAs as well. So keep an eye out for that.
Okay. And then, when you and I were talking, I said, well, can't the board just introduce restrictions? Can't, the board vote? Does it have to be document amendment? and you just mentioned it, but I just wanted to expand a bit on that. Number one, don't put any restrictions in place at all without legal advice. That's a recipe for disaster. And two, the strongest way to have any kind of restriction is a straight up amendment to your documents. Is that correct?
Correct. I mean, there's case law in Florida, James, that basically lays out the priority of the documents. And here's the difference. A board rule alone, you have to prove the reasonableness of it. But a recorded provision in your declaration is already cloaked with the presumption of reasonableness. And, you know, there's case law that has established that principle and that order of priority. You know, the other thing I would say is hopefully your association attorney, when they prepare that leasing amendment for you, is going to build in some flexibility. So I like to put in language in my leasing restrictions that says, you know, leasing will also be subject to further board rules and regulations. And as long as I've got that in there, in the superior document, now I can have my board over time pass a series of additional rules as they become necessary.
Okay, that's excellent. I want to, Ness, put up poll question 2, please. I wanted to just kind of give a management perspective, Donna, and get you to comment on, you know, what's wrong with rentals? Why is it such a big deal? And so this question is just asking you, and you can only answer one, the most important one, you know, what challenges you are having in your community in rentals. But we just had a great example this week, Donna, and I wanted to share it, where, you know, we have a large HOA. It has a high percentage of rentals. I suspect that's because a lot of them were sold investor from the beginning. And our management team's having a tough time. And the board, I don't know that from a management perspective, and whether it's a management company or self-managed, it doesn't matter. It's the same workload. You can imagine we need to, if it's a 500 unit community, we have to manage our relationship and serve 500 owners. Let's say half of them are rentals. Well, now we're serving 500 owners and 250 tenants. So it's a significant increased burden on management. By the way, I'm not complaining. I'm just saying that is the reality in a community association. The other challenge is that, you know, in fairness, unless you have a really good welcome process in your community, they don't know the rules. And so they may not even be violating them maliciously. They just don't know them as an owner would. So you do have that. But how about, I think maybe the best thing is let's share the results of our survey.
I would say this while we're looking at the results. I think there's a huge difference. Oh, wait, let me look here. So they don't care for the unit. They don't disruptive behavior, not following association rules. I think there's a huge difference, James, between long-term tenants and short-term rentals, okay? I think that distinction needs to be made. In some of my communities, they have tenants that have been in there for years, 10 years, 15 years. Those people do not tend to be the problem. Frankly, if they were the problem, they wouldn't be there for 10, 15 years. I think that renting overall has gotten a really bad rap because of the frequent short-term rentals we're going to talk about. I will tell you, in a lot of my communities, it's also a guest violation. You've got a lot of guests coming and going. You've also got people pretending that their tenants are really guests, right? Oh, that's just my cousin. That's my college roommate. When, you know, and that's a way that they use to get around any rental restriction. And if we have time, we can talk about how to prevent that from happening, how to crack down on that.
We had a question come in, you know, what about friends and family? So if we have time, we will certainly get that. I wrote it down amongst the other questions we're trying to get. But if you look at our survey results, Donna, clearly not following association rules is by far the #1 challenge we're having in our communities. So I guess that begs for #1, a better orientation for new residents, and 2, just enforcement.
But I would say this, before we get off that topic really quickly, that is the owner's problem. Okay, so what the owners need to understand when we're talking about educating, it's not just educating the tenants about the rules. It's when you give an approval to an owner that you're going to let him or her rent out the unit, you need to remind that owner that he or she or they are responsible for the actions or inactions of their tenants. So if the tenants, if 61% of our pollees are saying that the tenants aren't following the rules, That's the owner's problem, which means that owner is now subject to fines, suspension of common area use rights, and other legal action. And, we're going to talk about enforcement a little bit, but when I shut off that key, when I work with the board and the tenant's acting up and they shut off that key fob to access, that's a really big hammer, because most tenants, they're not only renting the unit, they want to enjoy the use of the amenities.
I put that in my notes later, a gated or a fob controlled community really helps enforcement, because as you say, you have the ultimate hammer. You can't basically get into the pool or up into the common elements. Okay, the other thing I wanted to mention just before I leave this part of topic is it does affect the culture. There is, if you're an owner and you're there with your family or whatever, and you're there for a long period of time, you invest in the community. Someone that's there for a year, and again, they could be the most wonderful people in the world, but they just likely aren't going to choose to invest, in the neighborhood part of our community. So there are significant real life management, legal, and culture, neighborhood culture. I don't mean ethnic culture. Just what's it like to live in the community? Implications of rentals. Okay, I think I want to put up question 3. Yeah, there we go. Because you mentioned big difference between short-term and long-term rentals, and I thought this would be good to give some context, Donna. What are our rental rules in our community? So we'll just let that run for.
If you're renting daily, you're a hotel.
Yeah. Well, but obviously we have condo hotels. Like that's not.
That's true.
True. We, or at least Castle does. So, okay, I want to move to rental restrictions, and so we don't have any. We talked about how we do it, but you had done a really nice list, Donna, when we talked about it, of the types of rental restrictions. And the first one was what you called a moratorium. What's that?
So that's a restriction, James, that a community might want to consider if they have, or they suspect that they have a lot of investment purchasers, okay? And basically the way to eliminate investment purchasers, or at least pump the brakes on them, is to impose a leasing moratorium via an amendment to your documents. And that would say, from the time you take title, new owner, you cannot lease out this unit for 12, 18, 24 months. I do not recommend going beyond 24 months, because at that point, it tends to be, perhaps be classified as an unreasonable restraint on alienation, which is not legal. So that's the first thing. If you impose a moratorium where if somebody buys and they want to rent, they're going to have to sit with that property. And the reason that's effective is because most people who want to buy for an investment, they want to start making money on that investment right away.
I read a recent article, I believe it was Community Journal, where that's exactly what one community did. Like a large institution was coming in and buying up units, and they put in a rule that you couldn't rent in your first 2 years. Well, that put the brakes on that. So that's moratorium. The second one is a leasing cap, like a maximum percent of the community that can be rented. Please tell us about that one.
So I do have clients that also impose a leasing cap. And the reason for that, like you said, a percentage, no more than 5%, 10%, or 15%. Most communities use that no more than 15%, James, because that's what the banks are looking for. When the association is looking to borrow money, and by the way, a lot of our mutual clients are going to be looking for financing as the milestone inspections near and all these repair projects become due after those inspections. They're going to be looking for money. And what are banks looking at? If you have more than 15% of your units rented, it makes you a much less attractive borrower for these banks. So a lot of times the leasing cap will be 15%. Now there's a couple things to think about with a leasing cap. Number one, housekeeping again. This is where you and Castle and other management companies come into play, because you're going to have to, your manager is going to have to stay on top of which units are leased. Are you nearing that cap? Are you exceeding that cap if you approve another lease? And also you have to decide as a board, how are you going to handle this? Are you going to do a waiting list? Are you gonna allow renewals? In other words, you don't want somebody to have, if I have a 15% cap on leasing and I have a unit, am I allowed to just keep renewing? Or do I get one bite at the apple, then I'm done and somebody else gets to do it? So there's a lot to think about with a leasing cap.
Well, one of the questions that came in is what about, and Fannie and Freddie have these rental restrictions. I think that's what you're referencing, but it is true. If you hit over the Fannie or Freddie threshold, it makes financing of all the units in the community more difficult. Another reason why actually a cap is one to consider. And then we have a minimum maximum lease term. So I assume you mean 30 days, 6 months, 1 year.
Yeah, so absolutely. If you go below 30 days, you have enough units both that are renting for fewer than 30 days at a time, you run the risk of your association now being treated legally as, public lodging. And then there's other laws that come into effect. So now there are some associations, we've got some in the Keys and in the Panhandle, other resort type places where they do allow short-term renting, and they understand the implications of doing so. But most of the associations want a minimum lease term and they want a maximum. And they also want to know how many times a year you're going to do it. So it may be no more than 30, no less than 30 days, no more than 12 months, 1 time a year. It could be 2 times a year. I have some clients that say a minimum of a 12-month lease. So this is a conversation for your board to have in terms of the type of restrictions you want to set.
Yeah, we one of the questions that came in was on short-term rentals and Airbnb and VRBO. Are those the same thing? And the answer to that, yes, we're just collecting them all in the definition of short-term rentals. Okay, and then so we have minimum, maximum, and the other one, you can have a maximum number of times you can lease a year. So maybe our 3 months is the most, and you can only do it twice a year. So,
right. And then you need to think about, do you want to allow a hardship exception or not? Because, you have somebody that's leased and now they die 2 weeks into the lease, or they are forced to break the lease because they've been relocated. Hardship exceptions can get dicey because there's true hardships and then there's just, hey, can you let me out of this restriction?
Okay. And the hardships, I hadn't even thought of that one until you brought it up the other day, but would we then recommend having some hardship language put into whatever document amendment that was surrounded rentals? Or is it just kind of a practice of allowing hardship? Or would you recommend?
Well, I wouldn't allow, here's where I would, James, and that's an excellent question. I wouldn't give a hardship exception for a leasing, a moratorium, okay? There's no reason I have a hardship. You don't have to buy in a community with a leasing moratorium. Where I might give a hardship exception and provide some flexibility is in that restriction on the number of times you can lease per year for that very reason, which is somebody could, have a death of the tenant. Again, you could do, I'm thinking about it now. If you did the leasing moratorium, you know how this comes up? If somebody dies and their children inherit the unit and they don't want to live in it and they want to rent it out. So if you have a leasing moratorium, it's anytime title is conveyed. So that means, yeah, if your adult, child inherits the unit and there's a leasing moratorium in place, there could be, instead of doing a hardship exception, I would draft that amendment to say children who inherit and need to lease out the unit are exempt from this. So there's a lot of different nuances here, and it really boils down to clever drafting of those amendments and working with somebody who's going to bring up all these possible contingencies.
Okay, so that's rental restrictions. Number one, you can amend your documents to have them. That would require a percent of owners to approve that amendment that is also document driven. Someone asked what percent. It depends on whatever your documents say. I now want to, so we've decided that we're going to allow renting. We've passed our restrictions. The restrictions reflect what where our building is and all of the dynamics that are relevant. So now we have people who want to come into our community, and there's this process that we often refer to as screening. So I want to start by putting up poll question 4 and I'm going to give our audience a little more time because there's 3 parts to it. Ness put up, it says, does your community conduct a personal background check? Do you perform a personal interview? And then have you ever rejected a tenant? And I wanted Donna to ask you about all of those. But while they're answering the question, how do I have authority to demand to be able to screen as an association? I'm not the landlord. Where does our authority come from?
It comes from that leasing amendment that we just talked about. You know, you're not just going to do an amendment that either imposes a moratorium or a cap or minimum maximum lease terms. As long as you're doing that amendment, you're also going to provide for screening provisions. Is a personal interview required? Is a background check? Can you charge a transfer fee? And what are the criteria upon which you can safely base a denial? So all of that should be in that leasing amendment, James. Now, if you've done a leasing amendment and the leasing amendment said that it was subject to further board rules and regulations, and you didn't put a personal interview into that leasing amendment, but it says further rules and regulations, then you can pass a board rule saying, you know what, we're going to require a personal interview. And during the pandemic, you know, this is how we started this whole dance here between Becker and Castle was, you know, we did a lot of those by Zoom, right? I imagine a lot of those interviews were conducted. Previously, people wanted to meet in person. Sometimes that can be a hardship if you're dealing with, you know, an international purchaser.
Okay, let's, Don, I want you to see the results before we keep going on screening. So does your community do screening? Yes, most. Interesting though. A good chunk, no, Donna.
Yeah.
Do you perform personal interviews? You know, closer to half. And then have you rejected? Yes. And I want to ask you some questions about that. In fact, why don't I just jump into that one? You know, we're not the landlord, we're the association. You defined how we get our authority to screen, but what can we say no to? How do we, under what grounds could we reject a tenant?
Well, I know you're not the association, not the landlord, unless it is the association renting out their unit or their home. But there is an expectation on the part of the members that in almost every association I've ever spoken, you know, group of people I've spoken with, that somebody is making sure that everybody around them doesn't present a risk, right? There's some expectation that there is some screening going on, that the new people moving in, there's 2 things. One, that they can meet their monetary obligations, their financial obligations, that they're not going to come in and immediately be delinquent. And number 2, that they're not going to present any sort of risk to the rest of the community, whether that risk is, you know, parking in the wrong spot, violating all the rules, or something more dangerous. Before I answer the rest of your question, I think it's a huge mistake, the 50% that said they don't conduct a personal interview, because on the same time, 50% more people who answered our poll said they don't conduct a personal interview, but 61% said their biggest problem is tenants don't follow the rules. Do you see the connection there? If you conduct a personal interview, it helps you explain a little bit more about what the board's and the manager's expectations are with regard to those rules. So
I recently bought a condo, and Kathy and I had to go in and do the orientation, and it was kind of fun because I'm like on the other side of the table for this, and they did a great job. What's that?
Did they know who you were?
Yeah, they did. And they let me in, so that was a bonus.
They went easy on you. So you asked the question, what can we base our denial on? Well, a couple things. There is a case in Florida, it was Coquina v. Mance years ago, and that case stood for the premise that you know, an applicant needs to be what that case referred to as facially qualified to live in the community. I'll give you a classic example. Somebody applies to live in a 55 and over community, and they're 25. Okay. Now, when you know as well as I do that in a 55 and over community, you need at least 80% of the units to be occupied by one person age 55 and over. In many communities, they aim for 100% of the units to be occupied. In that case, that applicant under the Coquina v. Mance case would not be facially qualified to live in that community. Other criteria you really need to put in the documents, because if you out of hand just disapprove, let's say that the language says, you know, the board has the right to approve or disapprove within 30 days after getting the application, right? Boom, nothing else. and you disapprove. Well, there's another Florida case, longstanding, what we call a seminal case in Florida. It's the Aquarian, I believe it's the Aquarian Foundation v. Shalom House, and that stood for the premise that if you deny without a reasonable basis to do so, you must buy. You have to substitute a purchaser. So those are two seminal cases in Florida that talk about, denying an application. What I suggest to you and our listeners, James, is that this is where, again, artful crafting of an amendment really becomes crucial. You can create a framework, and I've done this, and my colleagues here at Becker have done this for, thousands of associations. Denial for cause. Do we want to deny based on financial stability, a minimum credit score? For tenants, this is easy, or for purchasers too. If the person's already been in the community and they've created a disturbance before, let's say it's a tenant and now they're applying to become a resident, that's a no-brainer if they've already revealed that they can't comply with the rules. A history of nuisance, creating a nuisance in another community. And again, the criminal background check, which we need to talk about given the recent HUD guidance.
Well, let's talk about that. And then a question just came in. Does a personal interview open the door to potential discrimination claim? Talk to me. There was a question as soon as we began the webinar about the implications of the HUD ruling on criminal background checks. What are the implications of that ruling?
It's a huge change. So back in 2016, HUD issued a guidance that said that when it comes to arrest, criminal arrest, people of color have been historically subject to more arrests. So you can't just as a board rely upon a history of arrests to base your denial, of an application. Now, June 10th, 2022, HUD came out with another guidance and they've expanded that. And basically they've said, James, that look, when you're basing anything, any sort of a denial for housing on a criminal background, you have to tread lightly. So what does that mean? Number one, it means you need to have a policy in place. This is very important for our listeners to hear, because I guarantee 99%, maybe 100% do not have a policy in place regarding how they evaluate a criminal background, and what they do with that information. You need to make sure that the person that you're getting the report on, there's a lot of common names out there, is exactly your person, your applicant. That's number one. You need to make sure you're not using a third-party vendor, like one of these companies that uses algorithms. And this is what the HUD guidance provided. So in other words, some of these companies, James, and I'm sure you've seen many of these reports, they will come back and say approve or disapprove. They're actually using an algorithm to tell the board what to do. That is going to be very dangerous territory. What you want is you want to get the report without that algorithm, you want the information. You don't want some third-party vendor telling you how to digest and interpret the information. And then once you get that background report, you really need to have a serious conversation with counsel and do a little more digging. So the HUD's guidance has now said there may be mitigating factors, extenuating circumstances. Was this a violent crime, the conviction, or was it a non-violent conviction? Was it 30 years ago or 3 years ago? So there's a lot of factors. And the last thing I would say is you 100% can no longer base a denial on criminal background without discussing it with counsel and using counsel's opinion as your safety net.
I think there's a couple points I want to leave with the audience there. And because we've got 40% on the poll here showing they have rejected a applicant. But it's just the liability of rejecting an applicant is significant. And if you apply that across all the applications, it's worth seeking legal advice if you're going to reject. Don't reject without that advice would be what I'd say.
Advice, James. And you know what? I'm not suggesting that you don't reject candidates that are worthy of rejection. That 40%, there could be a lot of Coquina v. Mance rejections in there, which is not facially qualified. If I have a restriction that says no, commercial vehicles, and my applicant is driving a commercial vehicle and they're not willing to give it up, that's a facial qualification issue right there. So, again, there are times, and you can reject based on criminal background, but you better talk to counsel, and you better not just, you can't just stop at the criminal background. You have to you have to look at the whole application. Is this person financially stable? Do their references check out? There's a lot to consider here after the release of this guidance.
Okay, let's take the poll results down. Donna, I kind of jumped ahead of myself with the going right into can you decline, but really the process is we've got an approved document supported process for a renter in our community. There is an application. Can I charge that applicant a fee because it's going to cost the association some money to do the investigation of the potential tenant?
The answer is yes, if you have the ability to approve. So we occasionally come across an association that's been charging a transfer fee and they don't even have the right to approve or disapprove under their document. So that is a problem. And there have been class action lawsuits against associations that do that. So number one, make sure that you have the right to approve or disapprove applicants. You can charge a fee for years, James. It was $100. This last session, they changed that to, or maybe it was 2 sessions ago, to $150 with a CPI, a consumer price index increase. So that's good. They've actually increased it. But I will tell you, even with that increase, I'm hearing from clients that very often that's not enough to truly cover the background report. In that case, you've got a couple options. One is you can shop around for another company to do it within the fee that you can charge. Number two, I have had some associations, when we get back to that leasing restriction, that puts the obligation on the unit owner who is leasing out the unit to pay for and run the background check, and then to provide the results of that report to the association. I actually like that idea because I can't tell you how many people rent out their property and they never do their own background check. They don't know who's in their units. And I think so often, James, they don't want to know. And the association cannot share its background report with that unit owner.
You're answering all my questions before I asked them. So I want to, one of the questions that came in was, can we not, put pressure on the owners to do a lot of the stuff that we want to have done? And I think the answer is yes. But you just, one of the things I want our audience to be very careful, we're going to do with the authority of the renter a background check. And we're not allowed to share that information with anyone. In fact, we, of course, at Castle and all management companies, I think, would have a process so that information never goes beyond where it's supposed to. So it's not like we can just say, okay, we got it here and hand it to somebody else. I wanted to make that point, which you just brought up. So the other thing is the 150, it is not a lot of money. I brought along our, we use Tenants evaluation, and they have a sheet for different types of background. And if you have an international applicant, the cost can increase rapidly, let alone management time for doing this, and board time too. So I actually think the $150 is low, but it is the law that we live with. Okay, so I want to put up poll question 5, our last one of the day. And audience, thank you for participating. I'm sure you like to see what other communities are doing, and it's really helping Donna and me kind of shape some of our questions and answers. But we want to move, one of the questions that was asked right when we opened up the show was, can the association use a standard lease? And the context of that question was whether that was enforceable. I'll have to go back and look at the question. I don't know, ladies, bring up right to the top. I want to get the question right. So right now we're having both, are they using a standard lease or addendum, and or are they doing security deposit? So it'll be under, there we go. So an HOA master association, Donna, requires a standard lease to be used. So we as an HOA have to require owners that lease their units to use these standard leases. This seems illegal as a third party, not a party to a lease between landlord and tenant, to require them to enter into contracts with each other in order to lease the unit. This seems tortious.
So
maybe that may be coming from a lawyer. I don't know, Donna, but it frames the question nicely. number one, should an association have a required lease?
Yeah.
And I think this is going to be the more common one, should we have a standard addendum so that we don't worry about the lease as much as making sure this is added to it? So maybe answer both those questions, Donna.
The reason for this requirement, and I do make this suggestion, I suggest a standard uniform lease addendum as opposed to a uniform lease. But the reason for it is to inject some uniformity in the documentation. And I'll tell you why. Because you could write a lease on a cocktail napkin, right? If you had two willing parties, you could write up your lease on a cocktail napkin, turn it in, here's my lease agreement. At least I don't like to require a uniform lease, because I do think that creates, you might overlook something that the parties want to mention in their lease agreement. Did we want to look at these? Let's see, 35% have it, 42% don't, and 23% don't know. Okay. Here's why I like the standard lease addendum, because number one, the terms and provisions of the lease addendum are going to prevail over whatever agreement your owner and tenant made. But there are certain things from the association's perspective we need to address, okay? We want to make sure that if the owner stops paying us, we're going to go to the tenant to demand rent, which is our right under the statute, right? Back in the recession, the Florida legislature wisely passed that because you had a lot of people renting out their units, collecting rent, not paying the association. Now, why do we need a lease addendum for that if it's in the law? Well, one of the reasons is because if the tenant is forced to sign a lease addendum, we can make the tenant, this is all about education, know right then and there, hey, if your owner stops paying us our assessments, we're going to come to you for that rent. In the absence of that lease addendum, what we've seen over the years, James, is that the owner will tell the tenant, don't listen to the association. They don't know what they're talking about. But in the case you've got an addendum, all we say is, here's your addendum, which you signed, pay us the rent. So that's number one. We may want to address in that lease addendum that tenants aren't allowed to have pets or aren't allowed to smoke in the unit. And that's, if the tenant agrees to it, that's enforceable. The other thing we'll want to put in that addendum is the common area security deposit that they have to submit. And also that if the tenant breaks or violates any of the rules and regulations, the association has the right to evict that tenant on an expedited basis. And that's crucial because I get calls all the time about tenants that are problematic. The owner's not doing anything. They're not, the owner's out of the country, out of the state. They don't care. And everybody in the association's in turmoil. If I have that lease addendum that allows the association to evict on an expedited basis, that is a really useful tool.
Well, you've hit on a couple things. First of all, from a management perspective, a lease addendum is so much easier because what happens. The owner hires a realtor or rental management company, and they go sign up their tenant, and it's so hard to go back and get another lease signed. It's way easier. Just as soon as it comes up, we send the addendum, and there you go. But you did mention a couple things that we should have in there, and I'm not going to repeat them, but I did want to mention the right to garner the rents if the owner doesn't pay the association. This is an often misunderstood one and a great opportunity for the association to get their maintenance paid. Can you just expand on what rights the association has to collect rent from a renter to pay the association's dues, and when can they do that?
So again, this was something that was changed during the recession, and there is a statutory form, James, that you would send out if a unit is in collections, which typically they are, if the owner is not paying. Speak to collection counsel about when you can demand that rent from the tenant. I think it's at 90 days. Don't hold me to that, but speak to your collection attorney as to when can we start demanding rent from the tenant. And it was an extremely useful tool. I did want to take this, as completely out of order, but before I forget it, on that lease application, if you are going to run a check on somebody's credit, you need to specifically have that applicant agree to that, because that does impact their credit score every time somebody runs a check. So make sure on that application that the tenant, because they're providing their social security number, they check a box saying, I understand and agree that a check of my credit will be undertaken.
Yeah, I think this is especially important. I know we have a lot of self-managed communities that listen to the show, Donna. And, if you have a management company, we kind of have to do it for all of them. So we kind of have some boxes that got to get checked.
Right.
But you literally can't do that background check without that authority. So that's super, super important. Okay, so the other takeaway there is, don't forget you have the right to collect rent to pay maintenance, because we're running the association, not the owner's home. What about security deposits? Am I allowed to take security deposits? Should I take security deposits? And are these incremental to what maybe the owner is taking for the rental of their home? This is the association asking for a security deposit.
Right. Good point. This is in addition to whatever security deposit that owner is taking for any damage the tenant causes to his or her unit. So legally, the association can take a security deposit equal to 1 month's rent. And listen, in some of our communities, that's $12,000 or upwards. And in other communities, it may be $1,000. So you have to tie it to what it cannot exceed what would equal 1 month of rent for that particular tenant. But 100% association should be taking those security deposits, because sometimes tenants or tenants' guests will cause damage to the common area. Here's what you can't use the security deposit for, because I've gotten asked this question, James. Tenant is parking in the wrong spot. They had to contact the attorney. I wrote a letter to the owner. Owner told tenant to stop parking there. Now they have a bill. Can they take that out of the security deposit? The answer is no. The security deposit is for physical damage to the common area. But again, remember, overarching everything is the fact that that owner is legally responsible for all the problems the tenant causes.
The other thing I want to say about security deposits, a lot of our communities, of course, are collecting them. We put them in segregated non-interest bearing accounts. And the reason is because there's some laws about having to pay the interest. And if it's non-interest bearing, there's no interest to pay. So our best practice is segregated account, non-interest bearing. Is there any other advice you'd give on the maintaining of those security deposits?
Just that the onus is on the association to return any unused portion of the security deposit to the tenant. You don't wait for the tenant to make a demand for their security deposit back. Once the tenant is vacated and there's no damage to the elevators or in an HOA to the land, the plant material or the gates, you need to expeditiously return that to them.
Okay. As we always do, Donna, we're running out of time. I want to hit a couple more. Renters' rights as it relates to us on the board of directors of the association. What rights do renters have for information from the association?
Well, they're acquiring more rights. They used to have no rights. And then a couple sessions ago, they achieved the ability to request the association governing documents, rules, and regulations, which frankly, they should be given anyhow, so they understand the rules. And then in this last session, that milestone inspection, which I know you've talked about before, under SB 4D, renters are entitled to see a copy of the milestone inspection, as they should be. They're living in the community, so they should know how safe it is. The issue becomes often, does the renter have the right to attend meetings? Does the renter obviously not have the right to vote? There is some question if the unit owner gives the renter a power of attorney, then I believe the renter is going to have a little bit more rights to attend meetings.
You brought up something that we've seen in a couple of our associations where I have a parking spot or a cabana. I rent my unit out, but I still, as an individual owner, you can use the cabana and the parking spot. And a lot of the addendums to our documents are saying, no, if you rent it out, you're renting out, all of your rights that are acquired with that unit. Otherwise, you could literally having two people using the common elements. So that's something to consider.
Well, I'd love to ask you a quick question, because this is actually something that amazes me, is that in some of my communities, I have the renter really sucking up a ton of the manager's time, right? And I'm always wondering, that renter needs to be discussing those issues with the owner, the landlord. It's
And-
really,
and-
renter doesn't have the right to be sitting there saying to, you know, one of your managers, and I want this at the pool, and I need, those conversations they need to be having with their owner, who's the landlord, and then the owner can reach out to the manager or the association and address those issues. But I do feel that sometimes, and I understand why it's done, that the manager is bending over backwards, you know, to try to please a tenant, and sometimes it falls under the category of no good deed goes unpunished.
Yeah. Well, by the way, it's really difficult, Don, on a practical level. The renter doesn't know. The renter
Yeah.
thinks there's a management office and they come in. You're
Yeah.
right. And on a practical level, you've got someone standing in front of you. I've just been reminded, I didn't answer the question, can we do an annual screening process for a tenant? Obviously, we can do it when they rent, but what if they're renting for 5 years? Can we do a second screening after the initial one?
So the answer to that question is it all depends on how you structured your minimum and maximum lease terms. So if you, I mean, if you allow a 5-year lease and somebody's been approved, then the answer is no. But if you say a maximum of 1 year, no renewals, it's very important. Again, remember, I talked about this. Experienced counsel who's going to walk you through all these different variations. You need to address whether or not somebody can renew a lease or whether or not they need to create a new lease with the same tenant each year. So if they're creating a new lease with the same tenant each year, then the answer would be yes, that tenant would be subject to screening again. In many communities, they don't want to do that because why put the tenant through that? Why collect the fee? But it's certainly, again, it all boils down to how you draft the amendment.
Okay, we got 2 minutes and 2 more points I want to get out. Insurance. What can we require on the insurance front as an association?
I'd love to condition approval of a lease on the owner providing proof of HO6 policy, okay? And naming the association as additional insured. Why do I do this? Because the owner's asking you for something. I think, you know, turnaround is fair play. You ask the owner for something. It's in everybody's best interest that every unit is insured for the interior. So somebody's asking you, I want a lease, that's fine, but we want to make sure you're insured. Renters should have renters coverage. And that coverage is an HO4, can include relocation costs. This is going to become crucial for that, tying this in a neat bow, James. We talked about those elevator deadline, the upcoming deadline. In some of my communities, they've only got one elevator. They've got tenants, and the tenants want to know, you know, are you going to pay for me to move out? No, you should have renters insurance that pays for you to move out.
Last question. It's 1 o'clock. Evictions. Obviously, if I'm a landlord, there are rules and laws around me being able to evict a tenant, but I'm not the landlord. I'm the association. Can the association evict a tenant from an owner's unit?
So with a lease addendum, 100% and an expedited basis. Without a lease addendum, yes, but we have to go to court to get an injunction to do so.
Okay. That, Donna, was action-packed. I can't believe and I know we had to squeeze a couple of those in at the end. And for those that have questions I didn't get to, I apologize. You are welcome to send them in, that information at castlegroup.com. And also, I know some of you board members are listening and saying, I need the rest of my board to see this. I think, Ness, by the end of day today, this video will be up, and you're all welcome to review it or share it with your boards. In fact, we encourage it. Donna, thank you. Great to see you again. I know you're
round, James.
I know you're heading on a trip, so have a good one. I appreciate you doing this before you go. Audience, thank you for all you do. We know that the pay is terrible in these association positions, and you work hard and you have a lot of pressure on you, but your communities are grateful, and so are we. So looking forward to talking to you next month. In the meantime, we appreciate all you do. Take care. Donna, thanks for being here.
Thanks, James.
Bye, everybody.